Hi all. In this video we're going to talk about the tax matter, the dependent relative relief and what's called the grandfathered exception. If we think back to 1988, there was a relief at that time whereby an individual providing for a dependent relative, as it was defined then, in particular a widow, would qualify on sale of the property once the dependent relative had ceased to need it and occupy it. They would, the capital gain that arose would be exempt. Effectively, the owner who provided for their mum would receive an additional private residence relief. The fact that they were living in a separate building wouldn't compromise that. Now this happy state came to an end on 5th of April 1988. So setups after that date do not qualify for this relief. Capital gains tax on sale is calculated in the normal way, and typically for a home of that era, the calculation could be as much as £20,000 in capital gains tax on a property of a couple of £100,000, split two ways, say brother and sister club together to get mum a property, and they each faced a gain of 100,000. Each had a capital gains tax bill to pay in 2026 of some 20,000, so £40,000 at stake. Quite a lot of money. The exact circumstances of the case are going to weigh heavily, but there's lots of guidance, in particular in HMRC Capital Gains Tax Manual, and the reference is CG 65625. Interestingly, how I approached this particular case was to first go onto AI, and that sort of gave me a reminder. I qualified in 1985, so this was current then, and I had at the back of my mind, this is interesting, I dimly recall, whether from exams or from practice, a case of this kind. So the AI turned up the manual, and then I put a link to the manual into the AI. In my case, I use Google Gemini, which I found very reliable. So I put a link to the capital gains tax manual, and then I gave some relevant information there. For example, the individual, the setup was pre 5th of April 1988. In the particular case I was looking at, it was 1986. So clearly qualified as a setup. subject to all the other considerations in the manual. And of course, these days, you have to read the manual quite carefully because HMRC will, if they can, challenge aspects of this. You need to be prepared simply to deal with the challenge or nip it in the bud before it arises. And classically in the phone call to HMRC, I'll sort of say, well, I've considered this, and it doesn't seem to me the sort of for example, the relative must have occupied the property rent-free and crucially without any other consideration. Now, what about the case of payments, expenses that have been paid? Again, fortunately, there's guidance in the capital gains tax manual. So if you've done your homework and you've rung HMRC, you should be able to nip in the bud sort of any distressing representations by HMRC to seek to deny the relief. And if we look into the manual, there's lots of helpful comments again that the AI is throwing up. A clever friend described AI as the best work colleague he got, and typically in practice, this is the kind of case I'd refer to a tax consultant. But here AI is helping me do that. And I can read on the AI search, by concession, payments by the dependent relative, whether made directly to the taxpayer or third party on his behalf, are not regarded as infringing the requirement that no consideration is paid. ESC D20. So you have a reference, and in particular, those payments are council tax, the cost of repairs attributable to normal wear and tear, and other items, including mortgage payments and interest. Now this is all quite interesting because it's not uncommon for HMRC to assert that such payments such as this are relevant. We've sort of looked, as I said in my introduction, where the exemption applies, the individual can claim the relief as would have been given if the property had been the individual's only or main residence during the period of occupation by the dependent relative, and that this is in addition to relief for their own residence. That's the reference there is TCGA 1992, section 226(2). So that's all quite helpful and quite good news. As ever, you shouldn't cease to research the matter so that you're thoroughly prepared and look at the actual original text that you're referred to in section 226. Now, interestingly, obviously there's all sorts of things can happen. What if the relative were a man? What if, dad had retired to a property? For the purpose of the relief, the expression dependent relative is defined in section 2266 as one, the relative of the individual or of his wife, or who is incapacitated by age or infirmity from maintaining himself, a relative of the individual or his wife, or of her husband who is incapacitated, a mother of either who is widowed, separated, or divorced, whether or not she is incapacitated. A relative itself is not defined, so it could be inferred that any blood relative might be included if incapacitated by old age or infirmity. You might look at the second definition and say, well, that sounds a bit sort of non 2026, but in reality, back when the legislation was framed, the main issue was widows, in that typically husband and wife would outlive the husband. In the modern era, with such excellent healthcare, the normal things that would have felled a man come retirement in his 60s are now very successfully treated. So it's not uncommon to potentially have a relative in their 90s who would benefit, who would, claiming the exemption would be of benefit to the individual who provided the relief, provided the accommodation. Very interesting. I hope that's given you food for thought and a steer as to how I go about researching conversations with HMRC before they take place on particular issues. How you game, how you sort of game the circumstances and look at them in different ways. For example, had the mother gifted the property to daughter in 1986 and continued to live in it, does it still successfully trigger the pre-1988 dependent relative relief requirement? HMRC may treat the transfer of ownership followed by continuous occupation with scrutiny, but so that is then down to negotiation with HMRC. I would have thought for most purposes, even if it was a gift, that wouldn't transfer the other consideration clause. And again, this is a point where you perhaps refer it to a tax consultant to cross this bridge in advance should it apply in the particular case of your client. So hope that's been helpful, and till next time, bye for now.